This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together. Hi, everybody, and welcome. Today, we're going to be talking about a quick overview and a discussion regarding the hottest topics for HOAs and condos in Arizona in 2021. And so just wanted to give you a quick update on that. We're going to be discussing electric vehicle charging stations, water rights, diversity, discrimination, fair housing, concealed weapons, marijuana legalization, effectively using technology, infrastructure issues, capital contribution and transfer fees, reserve and security issues, pets, sex offenders, dealing with media, Xeriscaping, and grants from cities. We have a lot to cover today, so we're probably going to want to dig right in. So first of all, I'd just like to welcome everybody who's joining us here today from all over the valley and all parts of Arizona, maybe even other parts of our country. I can see our viewers joining us, which is awesome. It's great to be with you today. I'd like to just say good morning and welcome to our 8th class of our 2021 virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. I'd like to introduce myself first. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing HOAs and condominiums for the past 24 and a half years, soon to be 25 years in November. And my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have done that for many years. So I think I bring a good perspective here today for teaching these classes. For some of you who have been to our classes before, you know that I have been teaching classes for over 20 years for the different cities, towns, and municipalities all over Arizona. I really appreciate and love working with the different cities that have partnered with us here today. Of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. It's our pleasure to be partnering with them to provide free virtual education to you this fall and throughout the rest of 2021. So today we've got a potpourri of a lot of different hot topics regarding associations. And we're going to be also doing just a quick overview of the legislation that's pending that has been passed this year in the Arizona legislature. Any of the bills pertaining to HOAs and condos. There were 4 bills that are notable this year that I think you should be aware of. First things first, I always like to know a little bit about who's in my audience. So I'd like to just start out with our first poll question. Which city do you live in? Or which city is your HOA or condo in that you are here today asking or wanting more information on? So the different options, we have 10 options for you: Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, Tempe, or other if you're joining us from another city here today. So if you wouldn't mind letting us know a little bit more about you as we start this class, that would be wonderful. So the poll results are in. From Chandler, we have 15%, which is a great number of people here today. Welcome. From Glendale, we have 1%. From Goodyear, we have 4%. From Mesa, we have 4%. From Peoria, we have 11%. Scottsdale, 24%. Surprise, 3%. Tempe, 4%. So we have representation today from almost every city here today. So that's awesome. Thank you so much for being here with us. We appreciate that. Well, let's talk a little bit about what happened in this year's legislature very briefly, because we do have a lot to cover today. There were 4 bills that passed in the legislature this year. And these 4 bills all pertain to HOAs and condos that I'm going to be discussing. They will all go into effect on September 29th, 2021. The first bill is a bill HB 2170. What this bill does is gives attorneys who represent associations the ability to collect attorney's fees when pursuing a garnishment action against an owner. So this is a favorable bill for associations. And basically what it does is once we get a judgment against an owner, we can garnish their wages, their bank account, or their rent if they're renting their property. And now we can charge and recover our attorney's fees from the owners pursuant to statute. So that's a great new law for associations because previously we were doing the garnishments and we were unable to collect the attorney's fees. The second bill deals with political signs. This bill will extend the time a sign can be left up to 15 days after the general election. And so we'll be seeing this bill coming into play. Of course, it doesn't go into effect until September 29th. But in the November elections, we'll be seeing that this bill will definitely be coming into play because owners will be allowed to leave their political signs up a little bit longer. Previously, it had been 3 days. The next one I haven't been talking about much the past few months, but I am going to talk about today is mask mandates and the business exception. As we all know, we're carefully watching how the Delta variant is going to be impacting our children going back to school or already in school and the ability to meet in person. So this bill was passed early in the legislative session, so we were kind of calling it moot at the time. So much time had elapsed since the governor signed it. But as we all know, things are changing with COVID on a daily basis. So I just thought it would be notable to mention it again. House Bill 2770 deals with masks, and it says, no matter what any other law says, a business in this state is not required to enforce on its premises a mask mandate that is established by the state, a city, town, or county, or any other jurisdiction in the state. Now, obviously, the impact on this for associations is we are nonprofit corporations in Arizona. And of course, we're considered a business. And so if there should be any sort of a mandate by the state, although we're hearing that, that's unlikely based upon the communications that we're hearing from Governor Ducey, that the associations, if you so chose, you would not be required to enforce on your premises, so on your property, a mask mandate. Now, whether or not that's a good idea or a bad idea, we'll have to look at that if things come into play again, where people are masking up on a regular basis going forward. And then the last bill also is COVID-19 pandemic related, and it limits the liability of associations. So any plaintiff that might sue an association, if in order for the plaintiff to prevail in a pandemic related lawsuit, they would have to show that the association was acting, in bad faith, and if we can prove that we were acting in good faith, we will have a viable defense. So this year's legislature, as I said, ended on June 30th. The new bills will be going into effect on September 29th. The most notable ones are going to be, we can collect attorney's fees on garnishments now. And political signs can stay up 15 days after the elections. Mask mandates and limiting our liability on any sort of lawsuit that may be filed against the association are all notable things from this year's legislature. Okay, let's get into the topics for today. We have a lot to cover. What I tried to do when creating ideas and topics for this class was to come up with what are the most cutting edge topics that I think are really going to be impacting associations for the rest of 2021 and into 2022. And so we came up with some hot topics that are cutting edge. We also came up with some hot topics that are just regular topics that we hear about on a regular basis, or we're seeing an uptick in the number of questions on it. And so we have just a number of topics that I'm going to touch on briefly and give you my thoughts on it, make sure it's on your association's radars. And don't forget, I see that in the comment section and the chat sections that we have going, that you are able to ask questions at any time throughout the presentation. Okay, let's start out with our first topic, which is electric vehicle charging stations. Of course, this is a hot topic right now in the US. As you know, in early August 2021, President Biden signed an executive order that would push automakers to have 50% of all vehicles sold come equipped with plug-in, hybrid, battery, electric, or fuel cell powertrains by 2030. Looking at this, in addition to looking at the sales of electric vehicles throughout our country, they hit the 2 million mark in 2019. They continue to grow at a very rapid pace. According to EV Sales Blog, which is kind of like a blog for electric vehicles, registrations of plug-in electric cars rose 136% year over year for the period ending in February 2021. So maybe your association has already encountered this issue. Maybe you have already had an owner that comes to a meeting or writes you a letter or sends you an email saying, I would like to install an electric charging station for my electrical vehicle. What can the association do to help me? And obviously the issues are different if you're in a condo or you're in a planned community. Because in a condo, the electric vehicle charging station would need to be in the common areas. In a planned community, typically the owners would be installing it on their own property, and we wouldn't be as involved in that unless it was visible from neighboring property. But some planned communities are also receiving requests to have one in the common areas. So lots of issues coming up with this. So let's first start out with, is there any legislation in Arizona that pertains to this issue, that mandates associations or that mandates business owners have electrical vehicle charging stations? So a handful of states have already passed laws regarding the installation and use of charging stations for electrical vehicles. Some of those states are California, Colorado, Oregon, and Hawaii. These statutes in these states generally require compliance with zoning and building codes and allow community associations to impose reasonable restrictions on the installation and use of charging stations, as long as the restriction does not significantly increase the cost or performance of charging an electric vehicle. While the Arizona legislature has not yet enacted any laws regarding electric vehicles and charging stations, we do need to first determine whether associations, if their governing documents give the board discretion to install a charging system. Most will, but you may want to get a legal opinion from your attorney to determine, can we use associations' funds for this? Where can these be placed? Boards may also want to consider issues such as who's going to pay the costs to install, maintain, and insure the charging system, and who will pay the electricity costs. All of these things will need to be decided before your association can move forward with putting in an electric vehicle charging station. New parking spots may need to be created that are closer to, a power source, or existing spots may need to be converted to electric vehicle only spaces. In short, I think the things that I would like you to take key takeaways on this would be, we need to keep our eye on the laws in Arizona to see if there will be any new laws that come up pertaining to electric vehicle charging stations. You should reach out to your legal counsel if you're starting to have these issues, because there are definitely legal issues that need to be addressed, such as where is it going to go? Do we have to convert common area space? How are we going to pay for this? And we can help you through this process. We've helped a number of associations already, mostly condos, as they navigate the system successfully, and we'll be here to help you too if you need any help. So that's definitely one to keep our eye on, electric vehicle charging stations, especially in the next few years. Okay, the next topic we're going to talk about is water rights. And how will this directly impact associations? So remember that associations, many of you have a lot of green turf in your communities, and green turf, as we know, requires a lot of water to keep it looking green, especially in the summer months and when you're trying to get your winter lawn going. And so basically, it's important that you know some important developments that are happening in Arizona that are going to affect your ability to water those green turf areas. And so really the first thing that I'd like to mention is the Arizona Department of Water Resources has declared a goal of sustainable water supplies by 2030. And what does this mean for associations? It means that there are going to be major water reductions for associations in the future. And the Arizona Department of Water Resources has created management plans which are designed to hold the state accountable for water use. And there have been a total of 5 plans that are going to be enacted over 5 decades. Now, this started back in 1980, and it should be completed by 2030. So currently, we're in the 3rd management plan of 5. And so basically, this plan is affecting HOAs with more than 10 acres of turf. And water allotments in these communities are regulated currently by the state of Arizona. And it's currently are 4.9 acre feet per acre for turf and 1.5 acre feet per acre for low water use in landscaped areas like desert landscaping, and 6.2 acre per feet for bodies of water. So if you have a lake or a pond in your association, you are already being regulated on this if it has, more than 10 acres. So as it stands, this allotment is compatible with plant, turf, and tree water needs. So we're still able in phase 3 or the third management plan to basically have things business as usual. However, tighter water restrictions are definitely coming soon. The fourth management plan is set to commence in January of 2023. And this transition is going to promise some small water reductions for communities with 10 or more acres of turf. The allotments will be reduced to 4.75. So we'll go from 4.9 to 4.75 for turf, 1.5 for desert landscaping, which is actually the same for as it was in the third plan, and then 6.2 for bodies of water. So the main impact is going to be for turf in the next fourth management plan, which is going to start in 2023. So the final part of this plan, which will take place by 2030, is set to commence in 2025 or 2026. And this is going to reduce water allotments for turf to 4.77 acre feet per acre. And so, basically right now we're at 4.9, then it's going to go to 4.75, and then it's going to go to 4.77, or 0.74 acre for bodies of water, or 6.28 per acre for, 0.74 per acre for desert landscaping, and then 6.2 per acre for bodies of water. And so we're really going to start to see some reductions, of course, when you see going from 4.75 to 4.77, and then from 1.5 to 0.74 for desert landscaping. So these are all things that we need to keep on our radar as we move forward. The next reduction is going to be in 2023. Then the final reduction will be in 2025 and 2026. So what can your association do to deal with these different water restrictions that are going to be in place? First of all, you may want to start considering reducing water-hungry turf to reduce overall water consumption in your communities now. You may want to start talking now with residents about future water challenges, so this isn't a surprise to them in 2022, 2025, or 2026. You may want to start thinking about ways to reduce your water use. So transitioning to desert landscaping or desert adapted plants, checking to see if your city or town has any programs or grants to help your association as you transition to more desert-friendly turf or plants in your community. Some things that you can look at if you want to do a deep dive and find out more information on this, you can visit the Arizona Department of Water Resources website. And my office is going to be sharing that with everybody who's joining us here today on Zoom and also on Facebook Live. Okay, right along, kind of goes hand in hand with this, is xeriscaping, which is another hot topic. Some associations, thinking about these water restrictions and also looking at their water bills on a monthly basis, have already decided to switch from grass to xeriscaping, or maybe even to artificial turf to reduce water and landscaping costs. A word of caution: if your association is planning on making this switch, you may want to have a plan in place. Talk with your attorney. These issues, converting from turf to, desert landscaping or turf to artificial turf, are typically hot button issues. And people get upset about it because a lot of people move to the neighborhood because of the lush green grass, etc. And so you really do need to have a public relations campaign if you're planning on doing this. And you also need to talk with your attorney, because sometimes to convert these landscaped areas from turf to desert landscaping or turf to artificial turf, there's a large expense, and you may not have the money in your reserve to cover this. So you may need to be doing a special assessment. So make sure that you're talking about, this with your attorney, so that you're following all legal requirements as you're navigating through this process. And also, our firm has been through this with a number of associations, and we can give you advice on what the best PR strategies are so that you can effectively sell this to your owners as a win. I've seen associations hire a landscaping company to come in and do a whole photo presentation. And you could even do that by Zoom, or you could send out an email or a video on this so that people have a better idea of what it's going to look like. And I can tell you from experience that a lot of times when an association finds this to be, really controversial and negative and people want more grass, when they see the finished product of the desert landscaping with grass, some turf elements in there, and all the beautiful blooming desert plants, many times people think it looks significantly nicer than it looked before. And it looks significantly nicer all year round. So, just something to think about is if you are planning to do xeriscaping, check with your city to see maybe if there might be some grants that they can help you with. You may also want to consider having a PR, plan so that you can show people what you're planning to do to get buy-in, and then make sure you're consulting with your legal counsel, because there are some legal issues if you're changing the use of areas, and also if you're going to be having a special assessment to pay for it. Okay, let's switch gears and talk a little bit about discrimination and fair housing. So we have seen over the past year an uptick in the number of fair housing violations that are being alleged against associations. So I thought it would be just a good idea to do a quick refresher on what are some of our responsibilities as an association under the Fair Housing Act. And the Fair Housing Act is a law that predates all the way back to the Civil Rights Act back in the 1960s, and it has evolved over the years. And basically, it applies to all associations, whether you're a homeowners association or a condo. And the Fair Housing Act prohibits discrimination against an owner or a resident by the association based upon that owner or resident's race or color, religion, sex, including sexual harassment, national origin, familial status, so applies to families with children, or somebody's disability. And disability is really broadly defined under the Fair Housing Act. It includes any person with a mental or physical impairment that substantially limit one or more of their major life activities. And some examples of that would be like blindness, hearing impairment, mobility impairment, having HIV, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disabilities, head injuries, mental illness, and also people that are living in certain types of group homes. So the Fair Housing Act is a very broad federal law. And we have to be very careful that the association is not singling out anybody and discriminating them based on any of these protected classes that I talked about. And so many of these aspects of the Fair Housing Act apply to community associations. So you just need to be aware of the requirements to follow the law. So let's give some practical examples so you know how this might come into play. So frequently an association hears from a resident or an owner that they feel they're being discriminated against, or they're asking for something special just for them so that they can better enjoy and use the property. So again, what is discrimination? It would be if the association is treating an individual based upon their membership in a certain group or category, and we're excluding these restricting members from opportunities that are available to other groups. It can occur when the community association fails to allow an accommodation or a reasonable modification to the community's common elements. So what would be some examples? Well, first, let's talk about like an example of a reasonable accommodation. So a perfect example of this would be, let's say your association has a restriction that says no pets in your community, or maybe you have a restriction that says no pets that are over a certain pound, limitation. And so basically an owner will come to the association and say, I need to have this pet based upon my disability, and I need to have an emotional support pet. And as long as they provide a letter from a medical doctor indicating that they do need this pet, the association would have to relax or make an accommodation to the no pet policy or the pound limitation policy for a pet, and allow that owner to have that pet, even though, pets may not be allowed in your community, or even though that pet may be over the weight restrictions that you have for your community. So basically, it's a reasonable accommodation is after the owner has shown that they have a disability under the Fair Housing Act, and after they've provided us with a letter from a medical doctor indicating that they have a disability, we have to make a reasonable accommodation and relax the rule with them. Now, I get a lot of questions on this, because a lot of times boards are unhappy when they hear that they have to allow it. If you have to allow a pet under the Fair Housing Act, under whether it's a service animal, maybe for somebody who's blind, or a seizure animal, or maybe an emotional support pet, the association is allowed to violate their documents, even though your documents may have a pound limitation or say no pets. This is a special exemption that you're allowed to do under the Fair Housing Act. We can still require that the owner of the pet in this example follows other rules that you may have. So barking can't be a nuisance. They have to pick up after their pet when the pet's, going to the bathroom on the common areas, etc. So they still will be held to a standard of, being a good neighbor. And when you talk about this issue with them, you may want to talk about, the importance of picking up after their pet and making sure that the pet's not barking. Okay, let's give another example of the Fair Housing Act, which we also see. So a reasonable modification. So sometimes we'll get a request from an owner to install a ramp at the association's common area clubhouse, or a lift chair at the association's pool, or to cut a curb at the association's mailboxes so it will make it easier for somebody who's handicapped to access this area. And so typically what happens is the association receives a request from an owner, and they indicate that they're handicapped and that they're asking for this modification. And basically the big question is, usually in these circumstances, the disability is, you can see it usually right away, like the person's in a wheelchair, or maybe they have a walker, or maybe they're using a cane or something of that nature. The association can still request to see a letter from their medical provider, the medical doctor, asking, providing that this person has a disability and asking for this, whatever modification they're requesting for. The big question is can the association provide a modification? Yes, you can. And in fact, you probably are required under law to do it. The next question we typically get in, and make sure that you're reaching out to our firm if you have a question like this that comes in and you're just not sure, hey, how should we handle this? This person is asking for something, it's really expensive, or, we're not quite sure if we can even put a ramp in at the pool, or whatever they're asking for. And so make sure you're reaching out to your legal counsel or our firm, and we can help walk you through the different steps and questions you should be asking. The first question is, who pays? The association could pay for it if they so choose, but really the cost of the modification, if the owner wants it, if the disabled owner wants it, they are required to pay for it if the association chooses not to pay for it. Be real careful, proceed with caution when you're handling these requests, because sometimes there are far-reaching implications. So, for example, let's say somebody wants to put in a pool lift at the pool, and they are, have provided us with a letter from a medical doctor indicating that they're handicapped and that they need this to enjoy the premises. Those are typically pretty expensive, several $1,000s. And in most cases, the association is not going to pay for that. And so basically what will happen is that the disabled resident will pay for the cost of the lift chair at the pool. And then there needs to be something in writing that indicates who's going to maintain it. And if the disabled resident leaves, will it be removed at their cost? Or will the association maintain it after they leave? All of these things are things that should be thought about on the front end as you're approving it, versus later after the fact when it's more difficult to get people to do things. Just a couple things. We have a great blog on neighbor to neighbor feuds, which talks a little bit about associations having a responsibility to get involved when there's a neighbor to neighbor feud if one of the neighbors feels they're being discriminated against. That doesn't happen very often, but if you have a Hatfield and McCoy situation and one of the neighbors in your community is claiming that the other neighbor is harassing them, and based upon them being in one of these protected classes, the association may have an obligation to intervene in that situation, even though normally we don't get involved in neighbor-to-neighbor disputes. And so we're going to be sharing that with you on Zoom and by Facebook Live, so that you can look at our blog that we wrote on that topic. Also, we have a great cheat sheet called our Federal Laws Cheat Sheet. For those of you who are familiar with our firm, you may know that we have over 60 cheat sheets on a variety of great topics for associations. This Federal Laws Cheat Sheet covers Fair Housing Act, 55 and over housing, emotional support pets, how to handle group homes, and satellite dishes and antennas, a lot of great topics for associations right now. One parting note on group homes, just remember that under the Fair Housing Act, an association cannot prohibit a group home from operating within your association as long as they're properly licensed and as long as the group home is actually for the disabled. And so if you have a request like that, make sure that you're reaching out to our firm and we can help you through that process and help you determine whether or not it is a valid group home under the Fair Housing Act. And if it is, you will likely be required to allow that, even though it is a business. Okay, let's switch gears and talk about flags. We've had a lot of questions on flags recently, whether it's, can we fly a political flag? What type of flags are allowed under the statute? What about, some flags that we saw last summer on Black Lives Matter? How does the association navigate flags? So I thought it would be a great time to do just a quick little summary of what our law says and then some practical thoughts on flags. So first things first, Arizona law is very specific regarding what flags can or are allowed to be flown in an association by a resident. So, regardless of what your documents state, an association cannot prohibit the outdoor front yard or backyard display of any of the following flags. So first, the American flag, any of the armed services flags, such as Army, Navy, Air Force, Marine, Coast Guards, as long as those flags are being flown consistent with the federal flag code. The second grouping of flags that are allowed to be flown under Arizona law are the Arizona POW MIA flag. Third category would be the Arizona state flag. Fourth category would be the Arizona Indian Nations flag. And the fifth category would be the Gadsden flag, which is the Don't Tread on Me flag. The association can adopt reasonable rules and regulations regarding the placement of these flags. These rules can regulate the location and size of flagpoles and may limit the member to displaying no more than 2 flags at once, and also may limit the height of the flagpole to no more than the height of the rooftop of the member's home. And so those are just kind of like the basic restrictions. We cannot prohibit an installation of a flagpole in the front or the backyard of a member's property in a planned community. So bottom line is state law is pretty clear on which flags we cannot prohibit from being flown. And if you live in a condo, there's going to be some more restrictions on that. You're only going to be able to place it in your airspace, so hanging from your window and possibly off of your limited common elements. If it's in a planned community or an HOA, you're going to be able to put it any place you want on your lot. And obviously the flagpole, you're allowed to have flagpole. You should get approval from your association, though, before you install that flagpole. What do we do about these kind of outlier flags, though, that aren't part of the statute yet? And how do we handle when we see owners that are flying political flags or Black Lives Matter flags, or maybe offensive flags like the Confederate flag or something that would be offensive to others? And so these are all hot topics and a great topic to kind of talk about a little bit here today. So political flags, what we have been saying to our clients, really since April of 2020, May of 2020, when we started to see more and more flags of a political nature, were that we felt that they might fall into the category of political signs, and that, the association should be, not as restrictive on those, because it could be considered a political sign, basically. But, if you're going to be a strict constructionist, political signs can only be up for a certain period of time. And we're going to talk about that in a few minutes. So it's 71 days before the day of the election. And then now with the new legislation going into effect September 29th, 15 days after. But what about like Black Lives Matter flags or maybe pride flags? They're not covered under the Arizona state law. And, I don't know what each of your association's documents say about flags. Some associations' documents have very, not very restrictive flag requirements, and you can pretty much fly anything you want, flowers in the spring and fireworks in the summer or whatever. But some say no flags, or some say only the American flag. So what are some things to think about as you're navigating this as a board? Well, first, remember that, under Arizona law, there are 5 categories, and we went through them, of flags that are allowed to be flown. So basically, I would never, ever prohibit any of those flags because under state law, owners or residents are allowed to fly those flags. My opinion is that during these times right now where there is unrest in our country, I would probably be more reluctant to enforce political signs, any political statement signs, unless they are offensive, such as the Confederate flag is offensive, and we have sent letters saying you need to take that sign down. But some of these other flags, are a sign of our times, and I have noticed that some associations that take a really aggressive approach on like the Black Lives Matter flag or the political flags, they're on the front page of the news. CNN, is covering these stories, and that may not be something that you want your association to be involved in right now. And so, what we've been telling our clients is you may want to be more lenient on these other types of flags that we've seen become more prevalent in the past year. But I would accept a no tolerance policy on any flags that are offensive to others. Now, sometimes people will come to me in boards and they'll say, well, the political sign is offensive, or, another type of flag is offensive to some in the community, but not all. And, those are really tough situations to navigate. And that's definitely when you want to reach out to our firm to help you come up with a strategy that's going to keep you off the news and be fair and, have a peaceful and harmonious community. Okay, this is a great little switch over to, political signs, because we're just talking about political flags. Are flags considered signs? Well, maybe. And therefore we are, being more lenient on the political flags. So what does the law say in Arizona about political signs? So what it says is that regardless of what's in your association's documents, an association cannot prohibit the indoor or outdoor display of a political sign on that member's property, except that we can prohibit political signs being displayed earlier than 71 days before an election. And then after the election, there's this little caveat in the law now, until September 29th, we can make them take them down 3 days after the election. But then after September 29th, we're going to have to give them the longer period to keep the signs up, which is going to be up to 15 days after the election. So basically, what this law does is it allows owners to have political signs on their property within a restrictive time period. We have been more lenient this year, especially with the national elections and many state and local elections coming up here in the next few months. And we have allowed the signs to stay up a little bit longer if that's the will of your community. Okay, let's talk a little bit about cautionary signs and children playing in roadways. We don't see this happen very often, but there is this little, finite portion of the law, and it can be found in Arizona Revised Statutes 33-1801, and it talks about cautionary signs. And so how this all came about, like most legislation, is there was an incident that occurred in Scottsdale where an association was prohibiting an owner from putting out the children at play cautionary sign. And they got very upset about it and lobbied in the legislature, and shazam, we have a law now that applies to cautionary signs pertaining to children. So basically, just so you're aware of it, and it's on your radar for your association, if an owner wants to put a cautionary sign, in a residential area and the sign is removed within 1 hour of the children stopping playing, and it's displayed only when the children are actually present within 50 feet of the sign, and the sign's no taller than 3 feet, and the signs are professionally manufactured or produced, there's nothing that the association can do to prohibit those cautionary signs of children at play. Even if it's in your documents saying that's not allowed, it's not something that associations can prohibit. So it's just important for you to know that's just a finite law that's out there. The other really interesting part of this law, which is kind of actually ironic, is that it talks about children playing on streets in communities. And it says, regardless of what your association's documents say, an association shall not prohibit children who reside in the planned community from engaging in recreational activity on residential roadways that are under the jurisdiction of the association and on which the posted speed limit is 25 miles per hour or less. So when this law went into effect, I don't even know, maybe a decade ago, a lot of people, myself included, thought this is a little bit of a crazy law. We're allowing children to play on roadways where the speed limit is 25 miles per hour or less. But that is what the law says. So if you are in a planned community, this is something that you need to be aware of. And we see this come up from time to time where we have maybe kids that pull a basketball goal into the street, or maybe they're playing hockey in the street, or they're, riding bikes or scooters or whatever. All these things need to be kept. You need to be aware that, hey, if you're in a planned community and these streets are under the jurisdiction of the association, you have to allow the children to be able to play on the street. Okay, let's switch gears and talk about for sale and for lease signs. Just a quick primer on this. Remember that associations cannot prohibit for sale and for lease signs in condominiums and planned communities. We cannot charge them a fee to do the for sale or for lease sign. We can't prohibit them putting a for sale or for lease sign on the indoor or outdoor display in their yard or lots or units. If you're a planned community, it's a little easier because they can put it anywhere on their property. If it's a condo, typically they can only put it in their window, unless maybe they have a limited common element that's their exclusive use area. They might be able to hang it from there. The signs have to be industry standard sign, which generally does not exceed 18 by 24 inches. And the industry standard sign rider, is also required to be allowed, which should not exceed 6 by 24 inches. So the section only applies to a commercially produced sign, and associations can prohibit the use of signs that are not commercially produced. Temporary open house signs are also something that's covered by this law. So if you're having an open house, we can't require the use of a particular sign indicating an open house or real property for sale, and may not regulate the use of temporary open house signs or for sale signs that are industry standard size and that are owned or used by the seller or the seller's agent. So if you do have a real estate agent that's putting up temporary open house signs, you have to determine as an association, are we going to allow these from, the front entrance all the way in, all along the common area properties? You aren't required to, but they can only put them on their property. But you may want to allow it because obviously you want people to be able to sell their homes, and that in some cases is a way to get people traffic so that they can find a buyer. It's really up to you on that. We have to allow an open house sign that's temporary, but we can prohibit them placing it on the common areas if your board so chooses. We can limit open house hours. This usually is more for associations that have like a guard-gated community, where we want to limit the traffic coming in and out on an open house. And we can prohibit an open house being held before 8 o'clock in the morning or after 6 o'clock p.m. And so that's kind of an important distinction. If you're one of those associations that wants to limit it, that's what you can do. Most of our clients are not limiting for sale open house hours. And basically that's the rule. The signs apply to for sale and for lease signs. So just be aware that there are restrictions on associations, and we have to be careful if we're going to be telling a realtor you can't have a for sale sign or a for lease sign, because under the statute, they are allowed to have them. So I'm going to move on to the next topic, which is concealed weapons. I just got a question on this recently, just in the past few days. So the question that was presented to me was, there was an altercation on the property between an employee of the association and a resident in the association. And the employee of the association, after the altercation, it was a verbal one, but there was, a threat of physical harm to the employee of the association. The employee came to the board and said, would it be possible for me to carry a concealed weapon when I'm on the property? And the board presented that to me. And my response back was, I do not think that's a good idea for a number of reasons. First, I think it could potentially, if things escalated, it puts the association in the line of liability for allowing it. I think it does probably check with your insurance agent, but most insurance policies will be voided if you have employees carrying weapons on the property. Check with your insurance agent to determine, what your policy says. But this is a question that's come up because, as you know, Arizona has some of the least restrictive gun control laws in the United States, which include allowing a person over the age of 21 to carry a concealed weapon without a permit. And of course, there are certain limitations and exceptions to that. Arizona law does provide property owners the right to prohibit carrying of firearms on private property, subject to reasonable notice. And I do see that from time to time, when we walk into the library or we walk into a public building, courthouse, you aren't allowed to bring firearms into those areas. I also have seen it when I'm going to management companies for board meetings. I'll see signs frequently at the front entrance of the management company saying no firearms are allowed within this private property. So how does this affect community associations? So if an association holds a meeting, on-site or off-site, depending on the location, a firearm restriction may apply. So if your meeting's on or near school grounds, of course, they're never going to allow firearms. Libraries don't allow it. Management companies may not allow it. And your association may decide, after talking with your insurance agent, that you may need to post a sign at the sign-in that you're not allowing firearms at board meetings. If the offsite location is a private property, such as a management company or maybe the association's pool or clubhouse, the private property owner may prohibit the firearms, subject to reasonable notice. So again, if the association is concerned about this, you may want to post a sign at the meeting. There's some other thoughts to think about is that, the association can prohibit firearms. And, this may be something that your board hasn't discussed, but you may be having people come to your meetings with concealed weapons and you may not even know it. So it's something just for your board to chew on, think about, and decide what's going to be the best for your association. And definitely check in with your legal counsel or our law firm so that if you have questions on this or concerns, or if you have a board member or an employee of the association that's insisting on carrying a firearm, what's the best way to navigate that, especially get your insurance company in the loop to ask the question as to what their position is on this. Our firm wrote a blog on gun control in community associations, and we're going to be sharing that with you now in the Zoom forum and then also on Facebook Live. Okay, let's switch gears and talk about marijuana legalization. So as we all know, Prop 207 was approved recently and by 60% yes vote, 39%, almost 40% no vote. And that was in the 2020 general election in November. And so Prop 207 was approved, and it legalizes and governs the adult use and regulation and taxation of recreational marijuana. On November 30th, 2020, the Arizona Secretary of State certified the approval of the voters on this proposition, and this law became the Smart and Safe Arizona Act. Some counties, cities, and town ordinances may have restrictions and regulations on recreational marijuana. In fact, Peoria has enacted an ordinance of that sort. I guess the primary concern that we want to talk about for HOAs and condo boards is it going to result in increased recreational marijuana use on the common areas or on individual lots or units? especially if you're in a condo with shared walls and ventilations? And if so, how can the associations regulate and govern the use of marijuana in these areas? So first, marijuana on common areas. Let's address that first. So, according to the Arizona Legislative Council, this Smart and Safe Arizona Act does not authorize a person to smoke marijuana in a public place or an open space. And a person who owns, manages, or leases property can prohibit or regulate possessing marijuana on their property. So based upon this information, associations can enact reasonable rules and regulations prohibiting the use of marijuana on common areas. What about inside a lot or in a unit? This is a little bit more tricky, a little bit more of a gray area. The act permits individuals to consume and grow a limited amount of marijuana within a private residence. As such, it appears, that the act permits use of marijuana within a private residence. However, associations, CC&Rs, typically have a nuisance provision. And if their consumption of the marijuana is causing another person to not be able to peacefully enjoy their property, the association definitely has rights and can pursue that owner for creating a nuisance. So if you are in that situation where you have a situation where another owner is complaining about a separate owner or resident's marijuana usage and that's creating a nuisance for them, definitely want to reach out to your legal counsel, because there are some things that the association can do to prohibit that. Again, if your association doesn't have any rules on your common areas regarding consumption of marijuana, it may already be covered under smoking. It may be something that you'll want to update your rules. Another common thing that we've seen with the enactment of Prop 207 is that marijuana dispensaries are popping up all around the state of Arizona. And some of these dispensaries are in close proximity to associations, and associations aren't happy about that because they're concerned about the traffic and the noise and possibly, increase of crime, bad behavior, whatever. And so if you are getting a notice of a dispensary coming in your neighborhood and you're opposed to it, make sure that you're reaching out to our firm. We may be able to put you in touch with a zoning attorney that can help you with steps to fight it, or we may be able to just strategize about what your overall legal rights are in that situation. Okay, next thing we're going to be talking about is using technology effectively. I think we can all agree that there are a lot of benefits for technology, use of technology for associations. Some that come to mind immediately are this forum right here today, having a virtual HOA Academy where I'm teaching the class, and we have a large number of attendees who are able to listen in from the comfort of their home or their vacation or the Midwest or wherever they are during these summer months in Arizona. So being able to have Zoom meetings during the pandemic has been, amazing. Associations being able to communicate with their residents by Facebook, Nextdoor, emailing information, online newsletters, websites, all of these things are positive developments for associations. One of the things that I wanted to mention is talking about voting and using online voting. A lot of associations are now transitioning and allowing owners to vote, electronically, in addition to an opportunity to vote at a meeting for, let's say, your annual meeting or your special meeting of the membership or removal meeting. And Arizona, hasn't specifically addressed online voting. It doesn't prohibit it, and it does allow the use of email, for voting in an election. So a number of clients of ours have used online voting companies effectively, especially for associations with a large number of voters. It's been just a game changer for them that has made it easier for them to tabulate votes on the day of the election. And so this is a technology thing that is helping associations, along with some of the other things that we've talked about, using Zoom meetings and communicating with your residents through other technology-driven, means, whether it's constant contact for sending out emails or Facebook or Nextdoor. All these things are improving our ability to communicate with our owners and making it easier for our owners to participate in meetings and vote in meetings. So Just some closing thoughts on that. Online voting, in our firm's opinion, is allowable unless your documents don't allow for it, which, many documents were written so long ago, it wasn't even envisioned that would be something that we'd be doing. So it's our opinion, if it's not prohibited, you can do it. Remember that state law allows you to accept ballots by email. So many associations are doing that in addition to allowing owners to return them by mail, fax, and also attending the meeting in person and voting if they so choose. Okay, let's talk just briefly about some cheat sheets that would be helpful if you are interested in learning more about technology and virtual meetings. So our firm has 2 cheat sheets. One's on technology and community associations. The other one is on how to run an effective virtual meeting. We're going to be sharing those with you on Zoom and Facebook Live. And if you want a deep dive on these topics, those are great resources for you. Our firm prepared the cheat sheets, and they've been very popular. Okay, let's talk briefly on infrastructure issues. Obviously, after the high-rise collapse in Miami, there's been a lot of information, being discussed online on news shows about our high-rises and some low-rise condominiums really safe in light of, what happened in the Surfside tragedy. And so we have some publications that we think would be helpful for you that we're going to be sharing. And basically CAI, the Community Associations Institute, the national chapter, has really been a leader throughout the pandemic in providing free information. And with what happened at the Surfside tragedy, it's just another example of CAI National stepping up and providing really relevant and useful information to residents and boards to help them navigate any structural issues in high-rise condominiums or low-rise condominiums. And so we're going to be sharing with you a blog that our firm wrote on the high-rise collapse and some things that high-rises should be thinking about doing. Most importantly, check with your insurance agent to determine what is and what is not covered under your insurance policies. And then also you should be considering having a full 360 review by a structural engineer to make sure that your association structural components are, safe for your community. And if you do need to make some changes or improvements or upgrades, that you know what they are and you can plan and budget for them. And of course, if you're an association in that situation, please reach out to us because we're here to help. We've already had a number of high rises come to us and ask to have a special session with our firm to discuss, what their plan should be, and then also to discuss the results of their engineering reports. So make sure that if you are interested in this, I think my firm's going to be sharing the Community Associations Institute's information that they put out for high rises in the result of the Surfside tragedy. Okay, let's talk a little bit about transfer fees and capital improvement fees, and then we're going to talk a little bit about reserves and security issues, and then we're going to be almost finished for the day. So if your association wants to charge a transfer fee, it needs to be in your association's documents. And we have a cheat sheet that specifically talks about this issue. You can find all of our cheat sheets, of course, on our webpage for our firm, which is mulcahylawfirm.com. There are specific requirements if your association does want to charge a capital contribution fee or a transfer fee. We have them all listed in our cheat sheet, so I encourage you to look at that. Most important thing is it has to be in the CC&Rs and specific language has to be used. So we hope you'll take the time to look at that if you're interested in that topic. The next topic we're going to talk about is reserve funds and having a reserve account and having a reserve study for your association to plan for long-term capital improvements. We have a cheat sheet on reserves, which we will also be sharing with you. Or you can find it on our webpage, again, at mulcahylawfirm.com. Here's the bottom line on reserves. Reserve funding allows an association to prepare for the repair, maintenance, and replacement of the community association's assets as your community ages. And currently, right now in Arizona, you're not required to have a reserve study. However, planned communities and condominiums in Arizona with 50 or more lots are required to disclose to purchasers the amount of money they have in reserves. And they have to give a copy of the reserve study, if they have one, or a summary if it's over 10 pages, to any buyer. So right now there's no requirement to have a reserve fund, but just because the state doesn't require it, best practices does require that you really should have a reserve fund done reserve fund for your association. And you should hire a professional reserve company to analyze how much money you should have in your reserves. And our cheat sheet kind of outlines all of that for you. So I hope if you're interested in that topic, you'll take a deeper dive and look at that. Question that I often get is, what is a reserve study? It's just a guide or a plan, a comprehensive plan that shows you how much money your association should have in your reserves, how to fund it over a 30-year period. And a reserve company comes out, they usually charge somewhere between $1,500 and $5,000, depending on the size of the association and the amenities. It might be less, might be a little more. And it's just a great long-term planning tool for your association. Okay, let's talk briefly about security issues. So, we're seeing an increase in crime in associations. I think everybody can agree that, with packages being stolen off people's front, doorsteps, to, break-ins, burglaries, all kinds of different things, that we see in representing associations. We're notified when this happens. So we have a cheat sheet that I think is an excellent summary of how you can prevent crime and limit liability for associations. And we're going to be sharing that with you in our group chat here on Zoom and also on Facebook Live. What's the most important thing that you need to know about security issues in your association? Under the Martinez versus Woodmark case, which is a really important case for associations when it comes to what is our responsibility for keeping our common areas safe and free from crime. Basically, in that case, the court held that an association has a fiduciary duty to act in the best interests of your association. And by doing that, that you have to, take action to prevent foreseeable crime that could occur on your property. And so we give you some practical suggestions for how you can limit your liability in this cheat sheet that we're going to be sharing with you. And if you have this problem and you're worrying about it, it's basically general reminders, like reminding people to not leave their valuables, in their front seat of their car, if they're parking their car in front of their house, and lock the door. And to make sure that their garage door is closed. And if you have a series of, incidents that occur in your neighborhood, your board should be notifying residents that this is happening and may want to consider getting a security patrol. It just gives you a wealth of different suggestions to help you navigate it if you have this problem. Okay, next topic, pets. We also have a cheat sheet on pets. Pets are a huge pandemic issue because all of us, myself included, we got our pet, actually our dog Bailey, a little bit before the pandemic started. But I think we can all agree that during the pandemic, we saw an increase in the number of pets in associations. And so we have a cheat sheet that just talks about everything you need to know about how to handle pets in your association, from what to do if the dog's barking, to dog bites, to people not picking up after their pets, to, vicious dogs, to emotional support pets, which we've already talked a little bit about. Make sure that if you're passing any pet restrictions, like rules, that you're reaching out to your legal counsel or our firm to help you, to make sure that before you enact it, to make sure that it is something that is consistent with your documents and, is not in any way going to violate state law. But everything you need to know about pets, including how to enforce violations, is in our cheat sheet on this topic. And we're going to be sharing that with you in Zoom and by Facebook Live too. Okay, last two topics that we're going to be talking about are going to be sex offenders and dealing with the media. And then last but not least, grants from cities, how to get money. So sex offenders, typically we get this question when someone comes to us and says, hey, our association received a notice that a sex offender is moving into our association. How can we handle this? And so we've heard this question many times over the past 25 years. And basically what's happening is that there's Arizona sex offenders community notification statutes similar to Megan's Law. Once a convicted sex offender is released from jail and intends to enter and remain in Arizona, the sex offender has to register with the sheriff in the county in which they intend to reside. And then there's a risk assessment done to determine the offender's risk level. And, Associations typically receive notice when a registered sex offender moves into a community, and that's typically, it's in the discretion of, the law enforcement agency as to whether or not notification is given. So it's discretionary, but usually it's for the high-risk sex offenders. So state law requires mandatory community notification on all sex offenders assessed as a level 2 or level 3 offender. Level 1 offenders, there's more discretion, as I said, for the law enforcement agency to notify the association or not notify the association, but 2 and 3 will definitely be notified. What actions can an association take? Well, first, if the sex offender is, located near a school or a daycare center, many times that will already have been considered by the law enforcement agency in terms of there's certain distance that they have to be from those areas. What can an association do? You can check in with the law enforcement to make sure that the law enforcement is aware of, the distance between the location of the sex offender and a school or whatever. The association can send out the flyer that the law enforcement agency sends out, indicating just copy the flyer. And it basically is just the general information about the person. It's usually a photo, what level sex offender they are, what they have previously been convicted of, their address that they'll be living at. You could, post that, on the bulletin board at your community. You could send that notice out if the owner's living in your community. You could encourage owners to check out the Megan's Law website for the state of Arizona, and they can do the research themselves and not give them the notification. What are some things that the association cannot do? They cannot harass or otherwise intrude upon the offender's privacy, or if the offender's living with, their parents or a relative or a friend, we can't fine that person for bringing a sex offender into the community. So basically, our role will be just to notify owners that this sex offender is residing in the association. And the best way to do that is just to send out the notification that the law enforcement agency has provided. Many of your owners may have already received it in the mail, but I think it's something to consider for your board. Not all owners always receive it in the mail, so you may want to make sure that this is something that the community is aware of. And again, make sure that if you send that notice out, you make it clear that nobody can do anything to harass or otherwise intrude upon that sex offender's privacy. You're just putting the notification out there so that people are aware of the situation. Okay, last 2 topics are dealing with the media and grants with cities. What's the best way for associations to deal with media? Okay, let's be real here. Associations are not hearing from the news media on happy stories like we just converted our green turf to desert landscaping and doesn't it look nice? No. We are hearing from the news media when there is something that is negative or perceived as negative, an association behaving badly, an association treating somebody in a discriminatory manner. It's generally stories about associations that make associations not look in the best light. So how does your association best handle dealing with the media? And our firm actually has a cheat sheet on this topic. And you can find that. We're sharing it on Zoom and also on Facebook Live. So if your board is contacted by a media outlet, your board really should have a plan in place. The last thing you want to do is have a board member get on, the Channel 3 news camera and start, just talking because all that is evidence. And trust me, they'll clip it in a way that makes the association not be looked upon in a favorable light. So first thing I would say is have a plan in place. The plan we suggest is to contact your community's attorney to talk about the issue that they're raising, to make sure that, hey, we're making a good decision here and we're handling things in an appropriate and legally proper fashion. Designate someone to handle media inquiries. If you decide that you are going to make a statement to the media, our recommendation has always been it's best not to make a comment to the news media. And there are limited circumstances where you would need to, but in most circumstances, it's best not to comment. Why? Because the news media typically doesn't run the story. if there is no story. So in order to have a story, then you have two people fighting, right? The owner's upset about something and the association's behaving badly. So if you are contacted by a media outlet, talk to your attorney, make sure you're on strong legal ground, number one. Number two, really consider not commenting on it. Talk with your attorney about whether it's a good idea to comment or not comment. And if you are going to comment, make sure you have a plan in place, a pre-written statement, and don't take questions. We just think that's the best way to handle it. And again, you can look at our cheat sheet on this if you want to do a deep dive on it. Last but not least, grants from cities. Many cities, towns, and municipalities in Arizona have grant information. You can, as an association, you can apply for a grant, and maybe the city, town, or municipality will pay for half of a new sign at your entrance, or better lighting in your community, or converting from turf to desert landscaping. And so we know that we are specifically aware that the cities of Chandler, Peoria, Scottsdale, Surprise, and Tempe, they all have community outreach programs or neighborhood grant programs. And so if you live in one of those cities, you may want to contact these particular cities to obtain more information. And I believe that our firm is going to be trying to share for the cities that provided us with their grant information, that information, or you're always welcome to contact our office. You can contact me at bmulcahy at mulcahylawfirm.com, and I can get you the link to the grant information. Key thing on grants is act early. A lot of these associations are on fiscal years that ended at June 30th, begin July 1st. And so this is primo time to be looking into the grants and potentially thinking about some community improvement projects that the cities might be able to co-fund with you. One other thing is, once the money's gone, it's gone. They allocate a certain amount of dollars each year. And once it's used up, you'll have to wait until the next year. Okay, so we're closing up shop. As I said, this is our 8th virtual neighborhood services HOA Academy. So happy to be here today. I would say today's class probably had more technical difficulties than I've ever had, but I want to thank my team of Morgan and Yvonne for being here and helping us get through any technical difficulties that we had. Thank you for joining us here today. We had a great session, about an hour and 43 minutes where we were together. We covered a lot of ground today on hot topics pertaining to associations. And I'd like to just thank everybody for being here today and making your community better. And I'd also like to thank the neighborhood services from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe for their teamwork, genuine teamwork, and combining together to create these classes to provide free content for board members, homeowners, and managers so that you can be better informed about the laws that pertain to associations and do a better job managing and working within your communities. Please consider joining our next class. We have our 9th class of 2021 on our virtual HOA Academy on September 14th at the same time, 11 o'clock a.m. And for more information on that class, you're welcome to visit us at mulcahylawfirm.com. We have all of our upcoming classes listed. I think we have 3 separate classes, plus our First Friday's virtual call-in. So we have 4 different opportunities for board members, owners, and managers to get free information on how to best run their associations in September 2021. So check out all this information on our website at mulcahylawfirm.com and click on our upcoming seminars tab. Have a great week, everybody. I look forward to seeing you all in September. Take care, everybody. Have a great rest of the week.